Today is Monday, February 8th, 2000. It is my pleasure to be with Barbara Atwood, a 1976 graduate of the University of Arizona College of Law. For the University of Arizona James E. Rogers College of Law, I'm Donna Reem. Barbara, how did you decide to go to law school?
I took the LSAT and told myself if I was meant to go to law school, I would do well on the LSAT, and if I wasn't, then I would do badly. And I did well, so I went to law school. I was basically lost at that point in time. I'd been out of college for about 5 years, wandering around doing sort of temporary jobs, cocktail waitressing and secretarial work and teaching in some bilingual programs. I was looking for purpose.
And why Arizona?
I lived here. I was from Arizona. The University of Arizona was the only school I applied to.
How difficult was it to get into law school then?
I honestly don't really know. I mean, I was admitted rapidly. I don't know how many applicants they had at that point in time. I was really out of it in terms of sort of the whole gestalt of applying to law school. I didn't know anything about law school. I knew a few lawyers, ended up marrying one, and knew him at the time, and I thought it sort of appealed to me. The idea of being a poverty lawyer was what drove me into law initially. I mean, that's what appealed to me. But I don't really know how competitive it was.
How many students were in your class and what were they like?
There were 150 students, more or less, in the class. The major thing about that class, beginning in 1973, was that there were more women than there had ever been in the history of the law school. We had about 30%, so that meant, more or less 45 to 50 students that were women. And that was a huge change for this law school, and that was something that had happened nationally. There was a sort of phenomenon that we weren't cognizant of completely at the time it was happening. It was only looking back on it that we realized what a remarkable event it was. But the major thing that stands out to me is that there were all these women, and the school wasn't prepared for us.
Were the students from Arizona or were some from out of state?
I think back then, in terms of the composition of the class, that there were probably a similar balance to what there is now. I mean, I think it was probably about 25% out of state. I don't really remember.
Barbara, when you say that the school's unprepared for you, what do you mean by that?
When I say the school was not prepared for me, for us, it was just that there were, before this class that began in 1973, they had a maximum of about 10% women, and there was one woman's bathroom, and there were certain holdover customs in the school that fell off after we had been there for just a short period of time. Like there was an association called the Barristers' Biddies, which was, and that was really and truly their name, and they were the girlfriends and wives of the students who would appear at exam time like angels with sandwiches and cookies. And they were wonderful, but there was also something really odd about having these women wait on other women, and just their role seemed it seemed too subservient, and they abandoned, they dissolved or whatever within about a year of our starting in law school.
What was the average age of the students?
I would guess around, I was viewed as somewhat older. I mean, I felt a little bit older than the norm, and I had been out of law school for 5 years. Out of undergraduate school for 5 years. So I was like 26 or 27, and I think the average was probably more 23, 24. But there were a few people who were very much out of that basic population. Bram Goldman had had a career in another walk of life and came, and I don't know how old Bram was, but he may have been in his 40s. Peggy Houghton was in the class and was in her 30s, had raised a family and gone back to school after basically doing that sort of thing. So there were a number of older women.
You've mentioned how many women were in the class. How about people of color?
I don't know how many people of color there were. There were not many. There were some probably more Hispanic, Mexican American students than African American, although some very prominent African American students who've gone on to great distinction in the legal community were members of that class.
Who would those be?
Well, for instance,
It's okay.
Rainer Collins, who's now a federal district court judge, and was a judge on the state court bench for a number of years. Lena Rodriguez, as an Hispanic woman, was one of the first, if not the first, Hispanic women to be appointed to the Superior Court bench, and she was not in my class. She was a year behind me, but she's been obviously very prominent. And she was also a great basketball player on the courts. Very tough, combative.
Did everyone pass or did some flunk out?
Some were academically disqualified during our 3 years there. I do remember that. I actually put up a fight for a very dear friend of mine who was disqualified and has done quite well in another career, but it was very traumatic for those of us who stayed to see someone whom we thought would be just a wonderful lawyer, but sometimes some of the educational preparation for across the class was not even. Some people had gone to the Ivy League top prestige schools, and some people had had very mediocre educational backgrounds.
Were you involved with law review?
Actually, the year that I was eligible for law review, I mean my freshman year, about 5 or 6 of us who were at the top of our class were invited to join law review, went to 1 or 2 sessions of the review and decided against it. And this was contrary to the advice of large presences in the law school, such as Charles Ayers, who said, "You don't know what you're doing. You're turning your backs on this experience, which will help you immensely down the road." And I didn't know what I was doing. I just decided that I didn't want to spend the next 2 years in the basement of the law school with my skin turning green and working on something that I had no firm idea of. I mean, I wasn't quite sure what it all meant, but I also wanted to do some public interest law clerking and decided that that would be a better use of my time. Now, at that time, I had no idea that I would go into teaching, and to this day, it is something that when somebody happens to look at a resume or CV of mine, there are sort of raised eyebrows with, "Oh, I see, you didn't do law review." And I say, no, I could have, but I chose to do other things.
Was there summer school?
There was summer school, and in fact, I took some courses in summer school.
Did you participate in a summer internship program?
I did not participate in any kind of clinical work when I was in law school, or any sort of placement clinical class, which I regret. I think that would have been very positive, but I didn't do any of that. I felt at the time, I'm not sure it was right, but I felt that the more traditional academic courses were something that I would never have the opportunity to take again, that I felt that I can learn on the job once I graduate, but I won't be able to take law and psychology from David Wexler or the First Amendment from Charles Ayres.
So there were clinical programs at that time?
There were. Now, my recollection is that there was both there was an office on 6th Street that was kind of the neighborhood legal services office. So there must have been an in-house clinic, but I think it was very close to the end of that clinic. They did have some outplacement programs, but as I was saying, I chose not to do any of those.
What were the student activities?
Well, from my perspective, the student activities at the time were involved with the Law Women's Association. That was the major focus of sort of non-academic experience. We organized some conferences, attended a conference in San Francisco. A group of us, we actually set up that organization in our my second year, and then chartered a plane to go to San Francisco to the first Women in Law conference. That was a national conference of law students, women law students around the country. Stayed at a professor's house who had been a visiting professor our first year, and Roger Bernhardt. I still remember him. He taught us property law. He's from Golden Gate, and he put us up. We had like 15 or so women in sleeping bags on his floor, and went to this conference, and that was very inspiring. They had some very just great litigators from around the country who were doing cutting-edge women's rights litigation that seemed like something we could do. I mean, it was great to hear them describe their successes, and we brought that excitement back with us, I think.
Were there faculty-student activities?
Well, the only faculty-student activity I remember is the Law Women's Wine and Cheese Party, which doesn't really happen anymore, and I don't know whether its early experience is why it doesn't happen anymore, but we had a lot of drunken students and a few inebriated faculty members who gathered for the first time. The first time we had it was at criminal law professor Joel Feiner's house, and Joel was an interesting and unique person himself who had lived in his house for several years but never unpacked or hung the pictures that he had purchased for the house. So we went out the day of the party and sort of helped move Joel in preparation for the party, and bought cheap wine and cheap cheese. And it was packed. I mean, students and faculty turned out in a really, it was great because there wasn't, I don't think before that, there had been a very informal place for student and faculty to interact. There were some sort of stiff events like moot court banquets and that sort of thing, more traditional, but this was just fun, and it was a fundraiser, and it was successful from that perspective. So that's the only, really that's the only thing I can remember, those gatherings that were sponsored by the Law Women's Association.
Where did most law students live?
I think most law students lived around the university in apartments and houses. I lived in a tiny apartment about 5 blocks from the law school, which was then located on Park Avenue. And there were some married students who lived in Christopher City, which was a kind of, married student housing subdivision. But most people lived in these small houses or apartments. Mark Ulmer lived in a little tiny house on an alley called Bean Alley. I lived very close to Mark, and there was kind of a network of all of us in that area, just west of campus.
What were the job prospects getting out of school?
The job prospects at graduation, as I recall, were fairly good. I mean, I think people found jobs fairly easily. It was a healthy market. It was an expansion period for law firms. Some of us weren't interested in going into law firm practice. That I wasn't. I didn't even interview with any firms. I knew from the beginning that I wanted to do something more public interest. And I thought maybe going with an agency of some kind. I tried to get Bruce Babbitt to hire me at the State Attorney General, but he didn't want to. But I don't recall people worrying too much about employment. Now, having said that, there were also a number of people who just hung their shingles out. And some of my closest friends did that and have done very well, especially in the family law arena, where that's more common, I think. And it remained in either sole practice or in partnership with one or two other people for 25 years.
What was the bar exam like?
The bar exam was awful. It was a 2-day, very intense, not particularly intellectual test of memorization. I remember actually the exam itself not being that bad, because you knew at that point you were at the end of this deadly period of studying. It was the studying for the bar that I found so awful. The bar review courses were pitched in a way that was very different from law school, and what I had liked about law school was the interaction with the professor, sort of questioning ideas, thinking in ways that were creative uses of the law. And of course the bar exam and the preparation for that is nothing about that. It's only about, these are the ways you're going to nail this question, you want to put these words in, you want to memorize the 16 elements of X. And I didn't enjoy it, but I did have some study groups, some pals that I worked with, and I remember actually the very last 5 minutes of the bar exam in 1976. I was in a room, a typing room. Actually, I'll tell you about when I first started in the typing room, which was in the courtroom of the law school building. The bar exam was given at the law school, and it was somewhat cramped. And the very first day, we all got in there with our typewriters, and this was, in very early days. We're talking dark ages of technology, and I had my manual typewriter that had gotten me through college and law school, which I brought and set it up and put my paper in, and somebody walked in next to me with an IBM Selectric typewriter, and he had cables and he had extra little balls and things, and he was just, he had electricity and extra backup, this and that. He set his machine down, and the person who was administering the exam handed out the first set of questions, the essay questions that day, and said, okay, you may begin. And we all read the question, and we started gradually typing, and this guy next to me started groaning, and he started like pounding on his machine, and then he tore this little metal ball out. Those were the machines that whirled around, had little balls. Each letter was at one point. He tore the ball out, and he cast it away, and he put a new ball in, and the machine was kind of going like that, and the guy was tearing his hair out, and he went for 15 minutes. He struggled with this like state-of-the-art machine. Finally, ran out of the room screaming, "Does anyone have a pencil?" And we all just, you tried to just shut it out. I never saw him again. His machine stayed there, sort of like this dead, failed effort. And we just kept on typing, I actually didn't know him. He was somebody from out of state. He had not gone to this law school. But the last day of the exam, the last 5 minutes, I remember looking at the clock, and I had one question left, and I knew that I would be able to get enough down for that question, an essay question, what you can say in 5 minutes, but I was able to do it, and I was just looking around the room, and my good friend Peggy Houghton looked up right at that moment, and we looked at each other, and there was this, I don't know, just this wonderful recognition that we've done it, we're almost over. We knew that we were all going over to her house for a party right afterwards. And it was great. It was a real connection of friendship in that last sort of frantic moment of finishing the exam.
Who were some of your classmates, and what did they do after law school?
Well, my classmates included, a lot of people now who've done wonderful things in law. Peggy Houghton, as I've mentioned, was a very close friend, now a judge on the Superior Court. Karen Adam was a very good friend, who's a commissioner on the Superior Court, was a public defender and a juvenile court commissioner for quite a while. Margaret Cromwell was a very close friend who's gone on to an incredibly successful family law practice, mostly by herself, occasionally with partners. Steve Thomas was a good friend, and his then wife, Rita, whose name is now Rita Miser. She has become a partner and for many, many years at Jennings Strauss in Phoenix, and has done a great, sort of etched out a great world of practice for herself that not only includes the big time work of a large respected firm, but has focused on adoption law and been involved in some very important cases involving adoption practice and the Indian Child Welfare Act. And she's an example for me that I use for students, that even if you go with a big firm, you don't necessarily give up what you love to do. You can actually end up working along those lines after there's a period where you have to prove yourself, but then once you've got the respect and support of your partners, you can actually do that, and she's done that. Steve, her husband, has had a great career with a number of large firms. He's moved a little bit in his career. He graduated #1 in the law school, and as far as I know, at that point he was the only person to graduate with a 4.0, a straight A average. A brilliant guy. Julie Lauber was a close friend, and she's had a very interesting career working for the entertainment industry, doing actually some very high-level work for, I think, Paramount Films in Europe, and she's lived in Paris and London. Had just a very glamorous sort of life. Anyway, those are a few of the people.
How many students in an average class?
Well, the first year classes were large, like they are now. We didn't really have the small section program as it exists today, so all of our first year classes tended to be 75 people. I mean, they were divided in two. And the classes, in a way, when I think back on it, the classes seemed large generally, ranging from 60 to 75 for administrative law or corporate law or family law. But I think it's because the curriculum wasn't quite as rich as it is now, and there are a lot more choices for students. The faculty's a little bit larger now than it was then, so once that starts happening, the average enrollment in the classes goes down a bit. But some of my colleagues now were some of my favorite teachers then.
What subjects were taught?
The subjects that were taught look a whole lot like the subjects that are taught now. There hasn't been a lot of change in the curriculum in terms of core courses. That's one thing that law schools aren't real good about, is imagining new approaches to teaching the basics, even imagining what the basics are. Some folks who study legal education think we're really not doing it quite right, but most schools today, like most schools 25 years ago, divide the first year curriculum up into property, torts, contracts, civil procedure, etc. There was the beginning of a law and movement, law and psychology, law and sociology, I guess, law and social science. And that, I tried to take those courses because I found them interesting. There's a great deal more interdisciplinary work today than there was then. But what you didn't see back then that you might today are what might be called boutique courses. They're, just sort of specialized. We have a lot of offerings today in the criminal law arena that are that just weren't around then. Death penalty seminar or white collar crime. And I know that women in the law, it was taught occasionally by an adjunct. Indian law was taught by an adjunct, Jan Wesselman, who did a great job. I didn't take it, but that was not a standard part of the curriculum then. And the environmental law offerings were greatly, diminished compared to what they are now. And then, of course, the whole law and technology side of things simply wasn't envisioned back then. It wasn't happening.
How many classes were taken per semester?
The enrollment was basically the same as it is now in terms of what was considered a full load, and the graduation unit requirement was basically the same. So you had the students taking 14 to 15 class hours a semester.
What were the reading assignments like?
The reading assignments were probably in line with what they are today. They were, I remember the very first assignment I read in law school was with my criminal procedure teacher, Joel Feiner, who assigned us about 35 or 40 pages of this very dense textbook, and they were early criminal law, constitutional law decisions from the U.S. Supreme Court in tiny print. The margins of the pages were tiny, and I couldn't believe that I could ever do this work. It took me about 45 minutes to get through one page. I had no idea what I was supposed to remember, what was important. It was just daunting. That, for every law student, I think, who doesn't know much about what law study is about, that you go through that experience, and then you see, after a while, you begin to see what is important, and you get more familiar with the language, the reading comes more easily. But I think the assignments were probably basically the same length they are today, usually around 20 pages a night. I did take law and sociology from Kenny Hageland. I think that's what he called it. And we had very interesting non-traditional readings that included books and more lengthy assignments, but that was considered different reading. We also, during my period in law school, we started a law and literature class, which was not taught for credit, but was a well-attended group. Kenny Hageland was very much involved in that, and we had fun meeting at each other's houses. And Kenny also was involved in starting a law and film sort of forum, and that actually was quite successful. I wish we could do something like that today, because we'd get people from the community to come and be on panels following the showing of a particular film, who had expertise or personal experience in something that was relevant to the film. And I was always in charge of popcorn. We provided popcorn for the folks and would, use a theater somewhere on campus to show these things, and it was just, it was fun.
Were papers required?
Papers were required not for your non-seminar courses, but for seminar courses. They typically required a paper at the end. I guess Winton Woods tried to experiment with his teaching of federal jurisdiction, and yeah, he went to a sort of paper non-exam format for that class, a paper that actually took the form of some documents one would file in court, and including a lengthy memorandum on a motion to dismiss for lack of federal jurisdiction. And that was good. I liked that. That was a kind of group project. But mostly the formats, the models were traditional lecture, exam at the end, rest.
Oral or written exams?
There was only one oral exam that I recall, and it sent terror through all students. And I didn't take the course that it went with because people were so terrified, and I didn't want to have to go through that. And that was Junie Hoffman's securities regulation. He would give oral exams. And I remember one friend of mine who, a male, who came out of the exam, and he said he knew it wasn't going well when Junie asked him a question, and the guy had to say, well, which act are you talking about? Because there are two basic, there's the Securities Act of 34 and the Securities Exchange Act of 30-something. And they're very different in terms of what they regulate, and the whole course is about these acts. And he wasn't sure which act was even being referred to in the question. I think he passed, but yeah, Junie was the only one that I recall giving an oral exam. And along that line, there was only one teacher in that era who continued to ask people to stand up when they recited an answer, and that was Ray J. Davis, who taught first-year torts, and I got him as a first-year torts teacher, and it was intimidating. He was a very intimidating professor. He's a very nice person, a warm person, once you know him, not as your professor, but at the time, he scared us to death. And he would not just let you stand up and state the holding and sit down. He'd keep you up and question you, and question you until usually he reached a point that your knowledge stopped. So that you would sit down not on a high, proud note, but on a note of defeat. His approach to the Socratic method.
Were there off-campus events?
There were student parties off campus back then, a lot of informal gatherings. I guess there was probably a whole fraternity, legal fraternity scene going on, but I actually don't recall knowing much about that or going to those functions. But there were a lot of, there was a very strong sense of camaraderie among the class. I mean, really, very good friends, very good friendships were formed, and some of my closest friends are from that period. I met them in law school. We met at each other's houses a lot for just, talking about how school was going, for studying, for R&R. Few trips were taken down to Mexico with, some small groups.
What was the graduation ceremony like?
I don't remember much about the graduation ceremony. It was held in the theater, the old movie theater that's now been demolished down across campus. That was that was the place where they had enough seats and could sort of had a stage that worked for the law school's ceremony. I honestly don't remember who the graduation speaker was, which tells you a lot about the impact of his words. I think it was a man. And, you know, so graduation somehow wasn't as a meaningful an event, and I think partly it's because the bar exam review course started basically the next week, and it didn't feel like the end yet. There was a ceremonial ending, but there was still a big hurdle to overcome by the time, when that time rolled around. So the graduation, I don't remember much about the graduation. I don't know if Stanley Feldman spoke. Could have been.
How many faculty members were there?
How many faculty members were at the graduation?
I think just
Oh.
on staff.
Oh, how many faculty members were at the law school is hard to answer. I think it was probably somewhat fewer than we have now, maybe about 25. The first woman faculty member started when we were in our second year of law school, Mary Doyle, who arrived as Mary Pickman, and then she married Jim Doyle and became Mary Doyle. She started as I was saying, our second year. That was a big thing at the law school, to actually have a full-time woman professor. There had been a few adjuncts that were female before that, and Mary was young, and some of us were sort of old, so the year difference between us, the years it was small. I think Mary was maybe about in her early 30s, so she was 5 or 6 years older than I was. And she became a friend. I mean, I related to her not as a professor so much, at least once I took both the courses. I took 3 courses from her, I guess. Once I didn't have her as a professor anymore, she was really a friend, and I saw her again when I worked in Washington. She lived back there. She had a fairly high-level job with the EPA. It sounded good anyway. She was actually adjusting thermostats in the government buildings, but she married the city attorney, Jim Doyle, who was a great guy.
Were your professors accessible?
The professors were not too accessible, I would say, in general. The faculty all had their offices on I think maybe the 3rd floor of a 4-floor building. Maybe they were on the 4th floor. All I know is that they were up there, and it took a lot of nerve to go up there. I went up once to visit my criminal law professor, Joel Feiner, who is an odd human being, and who had no light in his office. I remember that. He had all the blinds closed. It was dark. He had an aquarium that had dried up apparently years earlier with the remnants of some mold on the side of the glass box, and it was a kind of creepy feeling to be in his office, and I actually never went back. They weren't accessible. There was a pretty big gulf between the faculty and the students on the whole, but there were a few very standout exceptions, like Winton Woods. Woody became a friend. He had an involvement in some law practice that my future husband, they collaborated eventually in trying to work out a public interest law firm, and they were actually doing that, I guess, towards the end of my law school career, and I began to clerk there. And so Woody was a friend and almost a colleague, more than a professor up on a pedestal. And of course Kenny and Andy Silverman were more student-like than professor-like, and they were young. But the older faculty, or the more traditional faculty, there was a big gulf there, and I think most students just figured that they weren't really. It wasn't that they weren't welcome, and I think I'm not faulting the faculty back then, but there wasn't a big effort to encourage visits by students. There was a new dean at the law school who started the year we started, and that's Joe Livermore. And Joe is a great and funny guy, but also kind of severe in his appearance, not in his demeanor. And I think he gave the wrong impression sometimes as being a very sort of rigid, strict guy. And we didn't feel like we were really wanted in that dean's office, that's for sure. And that kind of set the tone for those 3 years. Now I know Joe, and I see him as a kind of laid-back, guy who likes to laugh and is quite interested in people. But back then he was a pretty intimidating guy with a crew cut. He had been in the JAG Corps, and we didn't think we could mess around him.
Were your professors required to publish?
I believe that our professors had definite publication expectations in order to get tenure, but I don't think that it was as demanding or even as formal a set of requirements as it is now. And that's been typical of law schools across the country, that they've over time become more and more like other disciplines, other departments on campus, with a great deal of rigor applied to scholarship expectations. And today, you basically, when you set out to hire someone, you hire the people who have promise as a scholar, at least of equal importance as the person's promise as a teacher. That wasn't always the case, and I think that our law school career here probably was at the tail end of a period where there were fairly low expectations of publication. Now, there were some very brilliant scholars on the faculty, but I didn't have the impression that that was something that was emphasized greatly by the faculty, and I didn't know at that time of any faculty who had ever been denied tenure. There were, after our graduation, there were some cases of that occurring.
How did one become a law professor?
I think that the law professor career track is also something that's changed, and there were earlier in the history of legal education, you distinguished yourself as a lawyer. You would go into the legal academy after maybe a decade or more of very distinguished professional practice. And there were perhaps some people on the faculty of whom that was true. That's not the case today. If you look at who is hired at the law schools as beginning law teachers, most of them don't have a lengthy period of professional practice, and instead they're ideally they have a little bit of professional practice, they have very distinguished credentials and great promise as a scholar. And in the 70s, that orientation changed, I think, to emphasize more the person's potential as a scholar. Mary Doyle, when she came, she had graduated from Columbia Law School, as I recall, and maybe was only out for 4 years or so, and had worked on the Attica investigation. I remember the case that just recently, unbelievably, was finally settled. I mean, it's an unbelievable chronology that it's lasted this long, a civil suit that was brought on behalf of the inmates of Attica Prison. But Mary had worked on that at as a special sort of governmental appointment in the state of New York, and had had a clerkship, I think, and I don't think she had much more in terms of her practice experience, but she was regarded as a very smart woman who would write and publish in the in her areas of expertise, and which she did. But that she's typical of the trend in how you get to this career in the legal academy.
What were the backgrounds of some of the other professors?
I think that in terms of backgrounds of professors, some of them, Charles Ayres had just stepped down from the deanship when we started. He had come back from NYU. His career track is quite well known to everyone, with a clerkship at the Supreme Court, a distinguished practice experience here, and an academic tenure at NYU before he came here to be dean. Junie Hoffman had a very distinguished professional practice career with a large firm, but in the securities and corporate area. And he was more of the dimension of hiring after a distinguished career, as opposed to that trend towards hiring early in somebody's career and hoping that they'll work themselves into a distinguished scholar. But Charles Ayres had, as dean, had hired a number of young, promising people that affected the direction of the law school immensely, and those were Winton Woods, very early in his career, and he was spotted as a brilliant young graduate who did write and engage his sort of creative faculties with his subjects in a way that they predicted. David Wexler was another young hire, Arthur Andrews, Tom Schuessler was a young, brilliant law professor that was sort of spotted by Charles and his colleagues. And these, now they refer to them as the Young Turks, except that they're not Young Turks anymore. They really impacted the law school, I think. And there were some sort of a contingent of older faculty members here, and these new guys on the block brought sort of a breath of fresh air for the students in particular. Their ideas were exciting. Kenny, Andy, and Kenny, I think, was actually hired in a clinical line and moved into a tenure track line fairly rapidly, but brought his poverty law background and his creative ideas about what legal education could be to the law school, and I think they made it a better place.
Who were your favorite professors and why?
My favorite professors were people that I felt were interested in my ideas, my reactions to the material. And Charles Ayres stands out when I think back on it always, because he was such a great professor, both in a big class. I took constitutional law from him my first year, and he had a sea of faces, and he still was able to, I think, make each of us question our own understanding, but also think, gee, we may have some insights about this material that are worth something. But I took civil procedure from him, I took remedies from him in a summer course, and I took a First Amendment seminar from him. And those, each of those courses was very different one from the other, and taught in a different format. But he was just a very inspiring sort of head of the class in each one, and probably the capstone of it was the First Amendment seminar, my third year, and we just had a great group and very interesting discussions. There was a lot happening at that time at the Supreme Court. There's always a lot happening, but we felt like we were looking at a real dynamic, law that was going to change within our professional lifetimes and had changed, and it was, nothing stale. It all seemed like it was moving, it was happening, and I really credit Charles for doing that. He seemed very into it. And I think, we got him at a good time. He was very happy to be not dean anymore. He could teach. He actually spent a year, I think, at Harvard our second year. So he was gone for one of the 3 years, but was still a really vital presence. Woody's class in federal jurisdiction was excellent. He got us into a group project and made us feel like we actually could do something that was worthwhile out in practice. We were working as lawyers, as colleagues with one another, and that was exciting. Mary Doyle was a great teacher in front of a big group. She was hilarious. She was a very big performer and felt very comfortable, I think, in the way she interacted with a large group of people, and that was fun. It was fun to see a woman in that role. Bill Boyd was a great teacher. He's another one of the early hires in that group, a real important part of it. But I took civil rights amendments in a seminar format from him, and it was a demanding course, a really demanding course. I wrote a long paper with him. He gave me a lot of demanding feedback, which at the time I just hated. He made me question my conclusions and had I really justified particular leaps in logic, and it was so valuable for me, and particularly in what I now do as a scholar, that like close, intensive reading of my work, and I really think it was good, although I can't say that it was really fun.
Let's go with that one. She's already answered that.
You were in the Franklin building. What was that like?
That was a somewhat cramped building, classrooms that were, not amphitheater, but square down to a lectern at the bottom. As I have mentioned, there was one bathroom for women, and it was not a big bathroom, so that was always kind of a real inconvenience for all of us, although we bonded in the bathroom because it was such close quarters. But the building was really nondescript, and there was a student lounge. That's a glorified description of this sort of ante-room to the library, which was on the ground, the basement floor. And I have these memories of that place as just really disgusting. That was before anybody cared about smoking in buildings, and there was always an ashtray sort of overflowing with cigarette butts in this student sitting area, and empty soda bottles and coffee cups, and it just was. But on the other hand, we didn't really care. I mean, it didn't really matter what it looked like somehow. It was where we were studying law, and we felt pretty good about that. So the building, though, was not something remarkable.
What is the most interesting thing that happened at the college when you were a student?
The most interesting thing that happened when I was a student at the college is really hard to answer that question. I mean, I can tell you about some sort of funny things that happened, but I mean, one of the fact that there were so many women starting that year in '73 was in itself an interesting event that continued to sort of have ramifications for all of us as we went through the 3 years and afterwards. I mean, that's one of the most interesting features of my law school career, was being a part of that big wave of women. But one thing I can tell you about was my second year. We had a moot court final argument for the second year moot court experience, which I participated in. And we had flown out at the college. They had persuaded Justice William Rehnquist to come out for the arguments, and that was a big deal. He had been on the court for only like 2 years at that point, but he was a Supreme Court justice, and it was exciting. It was also terrifying for those of us that were in the final arguments. The other members of the panel included an Arizona State Supreme Court justice and a federal district judge, to my recollection. So it was a 3-judge panel, and the students in that final round were divided into 4 teams, and of 2 people each. So there were 8 of us, and one team would argue against the other in one session, and then a second team would argue against another team in a following session. And we happened to be, I and my partner, Karen Adam, happened to be in the second round of arguments, and so we were kept in a little room. We're not allowed to watch the first round of arguments because it's all the same problem, and it would have given us an unfair advantage to see the questions that this panel of judges had asked the participants. So we waited back in the lobby, and the courtroom was packed. There was only one courtroom at the law school that served as an appellate courtroom and a trial courtroom, and it was not large, and it was packed because everybody wanted to be there. After all, the Supreme Court justice was presiding in this moot court final round, and you know, those students who had parents among the contestants, they were there. You know, families came, so it was packed. It was a hot night in the spring in Tucson, and we were waiting. The first round began. We were terrified, and about 5 minutes into the proceeding, all of a sudden the doors flew open to the courtroom, and people raced out carrying one of the participants. And we thought, oh my God, this is a horrible panel of judges. And it turns out that the woman who had been the first one to argue had stood up at the podium, and she had gotten out, "May it please the court," and then she had fainted. I mean, fainted completely, dead away. She crumpled onto the podium and then onto the floor. And I heard that Justice Rehnquist was the most concerned of the 3 judges, and that he basically jumped over the bench where he was sitting to sort of minister to her, and they carried her out, and she regained consciousness and went back in and finished the argument. And it was so unnerving to see that. We felt like we were going in for a grueling battle. I always tell that story to my first year students when they argue moot court, because it's just so funny. And they were actually, when we went in, it was, it wasn't anything out of the ordinary. It was just it was just intense and scary because of the nature of the panel and the nature of the event. But we came through it fine, and Pam Porter, who was the woman who passed out, went on to a distinguished career in commercial law somewhere on the East Coast.